My closing remarks are not a planned talk. Before I speak, though, I have to clarify two things. One is, earlier when I talked about forensic science, I said the case to look at, which is the first retrial in 25 years of the Innocence Project in Philadelphia, I said Tony Snyder. Look it up, it's Tony Wright. Tony Snyder was actually the second exoneree we ever got out down there. Tony Wright, and it's a story in Rolling Stone. Secondly, as Michael pointed out, the Innocence Project in New York we have a staff of almost 80 people, and I did not have the pleasure of working on Michael's case. My co-founder Barry did with one of our most senior attorneys, Nina Morrison, along with a group of real kick-ass Texas lawyers who gave freely of their time and effort, who were fabulous. You know, there are so many interesting parallels between David Milgaard's case and Michael Morton's case. I could go on for a long time about it. I'm not going to. But what you have to appreciate is what we do at the project, and of course what Tamara's doing at the project here in British Columbia, and Adwig is doing back east, is this notion of not only exonerating people, but then using the cases to leverage criminal justice reform. Because the cases are important. It's great to liberate people who have no business being there in the first place, but unless you do something affirmative to change the causes of wrongful conviction, we will continue to have those problems in the future. Fortunately for us, Michael was like a one-man reform engine, and he mentioned the Michael Morton Act. And it did more than simply require that the prosecutor produce evidence of innocence before, during, and after. Texas used to be a closed file discovery jurisdiction, where it was very, very difficult for the defense to get into the prosecutor's files and see what was there in terms of police reports and witness interviews. And with his exoneration and the stroke of a pen from the governor and the creation of that act, it's now an open file discovery state. And so it's much easier for the defense to immediately find out all the good and the bad that's there. So lawyers can advise their clients when to plead, when to fight. It's made for a much more equitable and just system, and that came about as a result of what Michael had to endure. A second reform involving prosecutorial misconduct and police misconduct is the creation of something new in the United States. They're called conviction integrity units. And I think in part they were started in prosecutors' offices. You could certainly have them here in Crown offices as well. Maybe it's all the good press that innocence projects around the country are getting, and prosecutors wanted to get a little piece of that action. And so they've set up these CIUs, these conviction integrity units, and there are probably about 30 of them now around the country. Most of them are absolutely abysmal. They don't take their job seriously. They don't reinvestigate cases. In fact, when they interviewed the head of the Conviction Integrity Unit after it was formed in Philadelphia, he told the newspaper, "My job as the head of the CIU is to defend the integrity of our convictions." Okay? Now, in contrast to those kinds of folks, there are some units that are just fabulous. One in Dallas, Texas. One in Brooklyn, New York. Okay? Those two units alone have exonerated more people than the conviction review unit in all of England. Just two prosecutors. And they've been incredibly effective. And they're not effective because there are more wrongfully convicted people in those jurisdictions. There are wrongfully convicted people everywhere. We have, up until this year, there hadn't been an exoneration in Alabama. And when I brought it to the attention of the Attorney General down there, he had the audacity to tell me the reason we don't have wrongful convictions in Alabama is everybody is justifiably guilty. It's not the fact that the prisons don't have a prison law library, have no access to counsel, the racism in the system, the awful defense lawyer community that exists for those people. No, it's because their system is great. Well, what's so great about Texas is there are a lot of lawyers who do care, who fight. And the three jurisdictions that have the highest number of wrongful convictions proven, okay, are Texas, New York, and Illinois. And it's because in those three states, this whole innocence movement has really taken on steam. You have prosecutors who really care about these issues, and it makes a difference. And in those CIUs that make a difference in Dallas and in Brooklyn, there is a member of the team in the prosecutor's office who had been previously a full-time criminal defense lawyer or public defender. And that makes all the difference in the world. Because, Doug, I would take issue with one thing you said when the individual in the back raised the question about, wouldn't it be great to have outsiders in there thinking about things differently? It's not enough to have a contrarian within your team. The problems of groupthink that Kim brought up before, okay, in your presentation, the problems of people all being part of that culture, the problems of a blue wall, and people wanting to stick together, whether they're cops, defense lawyers, prosecutors, doctors, it doesn't make a difference. You need outsiders with a fresh view. You need people who are going to be inherently very critical of the status quo. They have to be part of the action. And unlike most of those other CIUs, Dallas and Brooklyn have those public defenders in there from the start, looking at these cases, judging them differently, asking the right questions, getting to the evidence, and thus exonerating all these innocent people. So that's a very, very important lesson from these cases. Another issue that's in both of their cases, okay, and in Michael Morton's case, they don't talk about it this much, but I learned it today from David when you talked about your case, is the role of the serologist. And Kim touched upon it briefly when he said that serologist who said, well, you know, even a known non-secretor might be secreting H blood group substances if it's a mixture of blood or if he has some kind of rare medical condition. That's not like, it's not just that that's a probabilistic statement, it's that that's misleading the jury. It's crap, okay? Because in 99.999% of the times, if you see the H blood group substance there, okay, and you got a non-secretor, you got an exoneration. If that serologist had been honest from the beginning, David Milgaard would never have spent all those years in prison. That's the point. And when people say, well, it's not my job as a criminalist, it's not my job as an expert to say everything, I'm there just to respond to the prosecutors or the defense lawyers' questions, that's hogwash. You're there as an expert, you have to give a complete and comprehensive answer. As part of that code of ethics that we just passed in Washington about a month or two ago, okay, it says that the expert witness can't just answer the questions, that he or she must give answers that are complete, that must be able to express the parameters of uncertainty, okay, and not sort of do anything that would mislead the jury. By talking about the possibility of some rare disease that I've never heard of causing that condition, and the possibility of it being a mixture with blood when in fact you can do a serological test for the presence of blood and that wasn't done there, okay? And even making those kinds of remarks when confronted with clearly exculpatory evidence is disgusting. I had never really heard the details of it until today, and it's so offensive. And in Michael Morton's case, you had the same thing with a serologist. In Michael Morton's case, they concocted this ridiculous theory, because they had no other evidence, that Michael did this because he was angry at his wife, because it was a birthday and they had not had intimate relations. And he had written a note on the mirror in the bathroom, okay? And so they bring in a serologist to concoct this stupid story and say, aha, and after he killed her, okay, he then ejaculated on her dead body. And so what I'm seeing here on the sheets is a neat semen stain. That's what it is. It's a neat semen stain. Well, that neat semen stain was looked at many years later, and it was a complete mixture of seminal fluid and vaginal secretions. It was the kind of thing that appears on anybody's bed, any couple's bed following intercourse. And it is a fact that every serologist, when they first look at a sample, looks at that sample under a microscope. And unless the person is dumb and blind, not only did she see the sperm heads that belonged to Michael Morton, but that she also saw the epithelial cells that came from his wife. And to bury that in her testimony is equally outrageous as it was in David Milgaard's case. Both those serologists deliberately misled juries. And whether it's lying or simply misleading, it is completely unacceptable. And are they outliers? No. Because we've seen it now in the United States in 42 of the 50 states, okay, and we've seen it in Canada, where all these different people affiliated with different laboratories mislead the finder of fact, okay? And it's not just a problem of the 1980s. We've seen it in the 90s and the 2000s. We've seen it in cases that are only 4 years old. And the one place where I would take issue with a lot of the other people here and the questions in the audience when you say, well, we have to hold the government accountable, okay? I'm not sure that works. I'm not sure, as much as it was satisfying to see the prosecutor who deliberately withheld that evidence in Mr. Morton's case, who then became a judge, spend his 10 days in jail, lose his license to practice law. Do I actually think that will have a deterrent effect on other prosecutors? I don't. Okay? I think they will continue to do what they've been doing in some cases, and the good prosecutors won't do it in the other cases. Similarly, I know, David, you brought up that, and some other people did as well, nor do I think compensation is going to fix the problem. You may have read 2 weeks ago in the newspaper that in Chicago, the city of Chicago has paid out $500 million in the last 8 years just to satisfy wrongful conviction cases and a lesser number of excessive force cases by the police department. It has had absolutely no effect on the conduct of the members of that force. Based on my 25 years experience, I think the single biggest thing you need to do is to change the culture, is to get people to think differently, is to get them to buy into a better system, a better approach to policing, to lawyering, to prosecuting, to judging, okay, than the one we have now. And if people begin to change that culture and think differently about what we want in the future, then and only then will you get the kind of changes that are long-term, that are substantive, and stick with people. So we have a long way to go to get that. I'm involved in the medical community. I'm on the board of a medical center in New York and a medical school. 25 years ago, we couldn't get a doctor to walk into the room and acknowledge that he or she had screwed up in the OR. No way. Fears of medical malpractice, of losing your license, it didn't happen. But by changing that culture and saying, if you come in and tell us that something's wrong, we're not going to punish you. Instead, we're going to reward you because you've alerted us to a problem that if we can now fix it, we will prevent future screw-ups in the OR. More lives will be saved. And by re-educating and training people to that new paradigm, we now have a situation where doctors are all coming in, telling us about the problems, and the quality of medical care is improving dramatically. So that's just something else to think about. You know, the other thing I wanted to mention, and then I will sort of move away from here, on the issue of false confessions, which is a topic that Richard Leo was talking about. Recording is great, okay? But now one of the things that the Innocence Project is getting into is, well, maybe we should think about changing the way we question suspects. Maybe, you know, it's like that situation of like those floating nets out there. You know, you set them to get tuna. And they do a good job of getting the tuna, but they also get the protected dolphins and porpoises. And it's the same thing with these interrogation techniques. We've been talking to people in the States who are from England, from some other European countries where they use the NICE technique, where they use techniques which don't involve lying and deception and the creation of false evidence. And they said that since they've been doing it, there's been no diminution of the number of convictions they get, of the confessions they get. And maybe they're not regular confessions. Maybe they're simply a guilty person making a false exculpatory statement and using that against the person at trial. But if you did those, if there was a change in the techniques, and it's something that we at the Innocence Project are going to be thinking about in the future, perhaps things would become different. Perhaps we wouldn't have as many false confessions as we do today. You know, David said that, you know, Michael Morton pointed out that the wrongfully convicted are a small sliver of prison society. David Milgaard pointed out that what we need is a more merciful system. And I agree with David in that respect. One of the biggest problems we have in the United States, much more so than here, is we have the over-criminalization of conduct in the United States. And we have mass incarceration. So we have far too many people behind bars, far too many people being pushed through the whole system, policing, judging, what have you. And as a result, there's less time, less energy, and less money to fix the causes of wrongful conviction. Because so much of the machine is being expended on pushing people into the system. So we have to be more merciful. We have to decriminalize a lot of the activity. We have to have fewer people in our penal institutions. And if we lower those numbers, there'll be a much greater opportunity to repair the causes of wrongful conviction and have a more just system, a more scientifically based system with empirical evidence, as opposed to a lot of unreliable evidence, a more reliable system. So those are the directions that we're moving to at the Innocence Project. Obviously, there's a lot more that needs to be done. We want to think about these issues in the future. In fact, we want to use them on ourselves. So we're about to do something we've never done before. We're going to join Tamara and a lot of the other projects, and for the first time, take on some non-DNA cases. But the non-DNA cases we're thinking of taking on initially will be limited to forensic science, because a lot of these other forensic disciplines are simply so bad, so unreliable, having never been validated, that they need to be addressed. But we're concerned, because when you prove how bad they were, you're not necessarily affirmatively proving innocence. We're going to require compelling evidence of innocence, but who knows? So in those cases, one of the things we're considering doing is exactly what Doug was asked to do at the police department. We're going to have a red shirt group. We may have some prosecutors who, before we go public on a case, based on our own investigation and our own retesting, challenge us. Challenge our assumptions and our assertions. Make us go back to the investigation, the drawing board, the lab, do more. Okay? Because we think we need to do that as well. We have our own biases. And boy, biases are an important thing. You know, those two serologists had a bias. They were part of a team. The team was out there to prosecute these people, and they were going to bend the truth a little bit. They probably didn't even think they were misleading or lying. Just bending a little bit to help get that conviction. You know, that cognitive bias is a big deal. In the States, you know, one of the biggest cognitive biases is implicit racism. It's there, it's everywhere. Okay, all the statistics demonstrate that it affects every single stage of the criminal justice system, particularly if you're black and poor. There is no question about it. And Canada is not immune from that either. Okay, I've had a lot of dealings with people from First Nations, Indigenous people in Canada, and I don't care whether they're the victims of crime in Vancouver or suspects of crime anywhere in this country, they are treated differently. There is more of a stigma, there's more of a presumption of guilt. It's less likely they're going to get out before trial. It's more likely they're going to get in after trial. And all of us, whether it's Canada or the United States, have to deal with those implicit biases, have to deal with those cognitive biases. And remember, it's not something that we can simply remedy. Other speakers talked about that. I think Kim did in particular, about how if it's implicit, you can't simply change it. So we need controls, we need rules, we need changing of the system to make it less likely that those implicit biases are going to create adverse outcomes. So we all have a lot of work to do. This conference is one step in that direction. I'm sure there'll be a lot more steps, and it's just my pleasure to be part of it all, and I bid you all adieu.